Moving on, myth number 9, user rights are a legal formality. Well, there are a lot of assumptions in India that many legal laws are just for formality. They are not. And with DPDP, I would always stress that don't just look at only legal things. Look at the impact loss of personal data can have on your business. Welcome to my YouTube channel where you regularly see new content on data privacy, DPDP Act. We have been talking about the myths, and we are on the myth user rights are nothing but a legal formality. Is it true? Well, as I said, a lot of people believe that a lot of components of our laws are only formalities. They are not. They are beyond formalities, right? You realize them when you get struck, and I am telling this about all the laws and not only just the upcoming or just coming in DPDP law. Consultants may misguide you that it's just a formality. When you get stuck, the consultants run away first, right? So be very careful and don't take any component of any law as granted or just being a formality. It is a law, it is a law, right? It needs real system changes. Why people believe that? Biggest thing that I have experienced in my 30 years of life. Interpretation of law, right? Because you don't know the technical language, you interpret it incorrectly. And I was talking to one of my consultants a couple of days back around the income tax things. There is a possibility that your consultant is not even competent enough to interpret it the way it has been made. So be very, very careful and don't take any law casually, including the fact, largely the fact about DPDP saying that the user rights are a formality. Remember, DPDP has been crafted for safety of the user. How can user rights be just a formality, right? They are handled manually today. You can automate them, you should automate them, and you should look at them as a real business growth factor also, rather than seeing them only as a legal issue. What do user rights actually mean? We have 5 rights under DPDP. Right to access my information. What information do you have about me? That can lead into finding out that you have my wrong phone number, or you have my wrong address, or I have shifted and my address has changed. So I have the right to get it corrected. I can come back to you and say, sir, you have put in my wrong address. Please put in the right address. Maybe you give me an interface where I update it myself. Attach relevant documents if you want me to, but it should happen automatically through me itself. That's the best possible thing that a fiduciary can offer. Right to erasure, I don't want my record to continue with you. Now, this is not something that fiduciary can offer to the individual to do it himself. Why? Because the fiduciary is liable to answer if in case that piece of information is required for a legitimate use or is under any legal obligation. In that case, the fiduciary is answerable to the government as to why this piece of information has been removed, right? So they cannot allow the right of erasure to be handed over to the individual principals, but yes, they can receive a request, validate it, and see whether they can erase it or not, depending on the other legal aspects. Right to grievance redressal, important. Where would the principal come and raise his concerns and his complaints, not only about the incident in the breach, but maybe about the user rights itself? He asked you for raise and you didn't raise, and he's not satisfied with the response, he can put in a grievance. And the right that is available only in India, which is right to nomination. Right to nomination says that when you provide me your information, you nominate someone with, of course, required validations. And nomination done to me would mean that in event of your death, what needs to happen with your personal information stored with me would be taken care of by your nominee. I can go back to your nominee and ask them how to handle this further. What DPDP actually expects? DPDP expects an intake mechanism for the user rights. How do you accept the request? Could be a part of grievance redressal, but could not be a part of the running service support systems in the organization. It has to be done separately for DPDP. And of course, if you are large enough to have those things, doing it separately in any case is a best practice. Verify the identity of person accessing the rights. Have some backend workflows who help you verify the nominee, verify the person who wants to access this information, verify the person who wants to get it corrected or even erased. A response timeline you should have in your privacy notice. And remember, this information has to be a part of your privacy notice. What response timelines, what are the workflows, and audit trails as to when was a request raised, when was it attended to, and when was it closed within your system. Why these rights fail when they are on paper? If there are no timelines, then there are no timelines. It's a non-compliant issue. If you don't have a proper system, then there are inconsistent responses. Someone emailed it to someone. Because you didn't tell me where to mail, I believe I mailed it to the right person. And you thought you are not the right person. No proof of handling, no audit trails, no regulatory exposure, in the sense that you should report it to the regulators that you have these systems, put them as a part of your audits and internal and external both, and put them as a part of your grievance redressal system or privacy notice as well. Key takeaways: the rights require systems, not just policies. Automation does help, and governance is required. Therefore, you need to take this as seriously that the user rights is not a formality, they are user rights. I hope you like the content of this video. Details about user rights available outside India available in my book, Data Privacy Simplified, available on Kindle. You can download, read it, and if you have any doubts, come back to me, both either here or through Kindle, and we can discuss it further. Thank you.